Hey everyone. Okay, so now we have managed to get through Wayfarer's opposition to Lively's Dalbert motions to exclude the testimony of their proffered experts. We're now going to go through Lively's opposition to Wayfarer's Dalbert motions to exclude Lively's proffered experts. So 2 weeks ago, each party filed a Dalbert motion where they said that the experts each of the experts for the other side, they should not be allowed to testify. Here's all the reasons why. And what got filed Friday just gone was each party then kind of responding to say, hey, no, judge, we want to keep our expert. This is why you shouldn't listen to the other side. This is why our expert is suitably qualified, has done all the things and checks off all the legal standard. So that is what we're going through today. So this is Lively now saying why the judge should ignore Wayfarer's motion to exclude Jennifer Freyd. And Lively's going to explain why Jennifer Freyd should be allowed to testify as an expert. Okay, the court should deny defendant's motion to exclude the testimony of Dr. Jennifer Freyd. Defendants seek to exclude the testimony of Dr. Jennifer Freyd, a highly respected trauma researcher whose social science research explains interpersonal dynamics that are routinely misunderstood by lay jurors. The defendant's motion rests on a fundamental mischaracterization of what Dr. Freyd actually offers. They repeatedly and incorrectly relabel her social science testimony as medical opinion, then attack that straw man under Federal Rules of Evidence 702. Defendant's arguments fail upon a proper characterization of her testimony. First, Dr. Freyd's opinions are admissible because she offers research-based testimony explaining the patterns of behavior, specifically DARVO, betrayal trauma, institutional betrayal, and betrayal blindness, and applies that framework to this case. She provides context on complex dynamics, including how an individual can continue working in a workplace relationship even after the company betrays her, and how an accused can escalate his response to allegations against him from simple denial to aggressive attacks on the victim's character, ultimately reversing the role of victim and offender. This is a retaliation case arising from defendant's campaign to bury Miss Lively after she complained of workplace harassment. Dr. Freyd's testimony is crucial for the jury to assess defendant's post-complaint retaliatory animus and defendant's claimed reasonableness of defensive measures. Without this expert context, jurors risk misconstruing that an aggressive counterattack necessarily implies falsity of the underlying complaint, rather than understanding that it can itself be a predictable response to being accused. Second, Dr. Freyd's opinions are not offered as medical evidence of emotional distress or to support garden variety emotional distress. Instead, Dr. Freyd will testify to research-based testimony describing patterns of conduct that are crucial to assist the jury in evaluating evidence involving complex interpersonal and institutional workplace dynamics. The court's order precluding medical evidence of emotional distress does not impact upon such social science testimony. No, but her report was talking about suicidal ideation and self-harm and all. Like, there's no need for that, because Lively can't bring that in. Third, defendants do not dispute the validity of Dr. Freyd's underlying theories, which they concede are reliable in general, but rather contend that Dr. Freyd's opinions are unreliable as applied, because she did not conduct a clinical evaluation of Miss Lively. That argument misunderstands both Dr. Freyd's expertise and her opinions. Dr. Freyd is not a treating clinician and does not purport to offer medical diagnoses. Her opinions are grounded in decades of peer-reviewed research accepted methodologies, and established research tools. Rule 702 does not require a social science expert to perform a medical assessment, and defendants cite to no authority imposing such a requirement. Fourth, defendants' mischaracterization of Dr. Freyd's opinions as improper summation is incorrect. Dr. Freyd does not resolve disputed facts, assess credibility, instruct the jury on law, or tell the jury what result to reach. Opining on a research framework generally and applying that framework to assumed facts is not impermissible summation. Her report repeatedly emphasizes that her opinions are based on assumed facts, precisely because factual determinations are reserved for the jury, and any question as to such assumptions goes to weight, not admissibility. Finally, defendants cite to no authority requiring wholesale exclusion of Dr. Freyd's testimony. Excluding Dr. Freyd's testimony entirely would distort Rule 702's purpose far beyond its gatekeeping function. Okay, background. Dr. Freyd's extensive background as a highly respected researcher. Dr. Freyd is a highly cited and respected researcher and professor of clinical and trauma psychology. Her numerous publications have been cited in research literature over 27,000 times. She has been awarded numerous honors, including the highest honor by the American Psychological Foundation, the Gold Medal Award for Impact in Psychology. Freyd is not a therapist or licensed clinician. Instead, as defendants acknowledge, Dr. Freyd is a trauma researcher who focuses on behavior and specifically the psychology of trauma, as well as the impact of interpersonal and institutional trauma on mental and physical health, behavior, and society. Dr. Freyd pioneered interconnected theories that have been extensively researched and relied upon by respected individuals in the field. These theories focus on patterns of behavior in perpetrators, conduct, and victims' responses. DARVO. Dr. Freyd introduced the term DARVO decades ago. It occurs when perpetrators and their defenders may deny the behavior, attack the victim, confronting them, and reverse the roles of victim and offender. Well, Jesus Christ. Look at Blake Lively, who's now an expert in domestic violence after she completely ignored it throughout the entire promotion of the film. Research shows that DARVO is associated with reducing the believability of victim reports when heard by third parties. Education about DARVO can reduce its negative impact on victims and observers. Betrayal trauma. Dr. Freyd introduced the term betrayal trauma in 1991. It concerns the nature of the victim-perpetrator relationship and occurs when someone you trust and/or someone who has power over you mistreats you. Institutional betrayal. Dr. Freyd introduced the term institutional betrayal in 2007. It occurs when the institution an individual trusts or depends on mistreats that individual. That mistreatment can be through acts of commission, such as employers harassing or retaliating against an employee, or omission, such as a failure to protect when there is a reasonable expectation to be protected, such as when an employee who reports being sexually harassed continues to be victimized after their employer fails to take action. Research shows institutional betrayal is related to measurable harm and is assessed using a research tool that is not a medical assessment. Betrayal blindness. Dr. Freyd's related theory, betrayal blindness, is the unawareness, not knowing, and forgetting of betrayal traumas by victims, perpetrators, and witnesses to preserve the friendships, institutions, and social systems on which they depend. It can lead to, for example, minimization of the significance of the event and delays in disclosure. Dr. Freyd's opinions generally and assuming the truth of the allegations. First, Dr. Freyd provides an extensive research framework explaining her theories. Second, Dr. Freyd applies that research framework to assumptions to offer two as applied opinions. 1. Miss Lively has experienced and continues to experience betrayal trauma, institutional betrayal, and DARVO perpetrated by defendants. 2. Defendants' actions put Miss Lively at increased risk of the symptoms of distress consistent with research on the mental and physical health impact of betrayal trauma, institutional betrayal, and DARVO. How is this not going beyond garden variety? You don't need to be talking about distress. Okay. Dr. Freyd's opinions are admissible to contextualize complex interpersonal workplace relationships, including those at issue here. Dr. Freyd offers research-based testimony describing patterns of conduct that are crucial to assist the jury in evaluating evidence involving complex interpersonal and institutional workplace dynamics. Courts routinely permit expert testimony that provides jurors with information to assist them in evaluating and placing into perspective conduct that may be the result of complex interpersonal relationships that could be difficult for a jury to understand on its own. The Second Circuit regularly upholds the admission of expert testimony to explain conduct not normally familiar to most jurors. For example, in Pollock, the court affirmed the admission of expert testimony on the general dynamics of sexual abuse, including coercive control tactics, because given the complexity of these types of interpersonal dynamics, they were beyond the ken of the average juror, and the testimony could aid the jury in assessing the relationship between and behavior of the defendant and his victims. Similarly, in Bird, the court permitted expert testimony on battered women's syndrome. Oh my God, really? That helped contextualize a victim's behavior, including that women who exhibit symptoms of battered women's syndrome are often under the coercive control of their abusers, such that they feel compelled to do everything the abuser demands in order to avoid provoking his disfavor. And one of those things that a woman who suffered real abuse and felt this level of vulnerability would not do is then attempt to steal something said abuser had been working on for 5 years and financing and pouring his heart and soul into. That's what she wouldn't do. Additionally, courts permit expert testimony that opines on both social science theory generally, as well as application of that theory to the present case specifically. For example, in EEOC, the court permitted expert testimony on social science research about gender bias in the workplace, including the effect of gender stereotypes on personnel decisions, as well as application of that social science research to that case to assess how these stereotype types, yeah, I had to check that, stereotype types may have affected defendants' decisions. Here, each of Dr. Freyd's opinions satisfies Rule 702 by providing a framework to understand trauma response, without which the jury will prejudicially fill gaps with lay misconceptions. Testimony on DARVO is admissible. No. I find this wild that we're even talking about stuff like this in the circumstances of this particular case. Dr. Freyd's testimony on DARVO provides critical research-based context for the jury to evaluate defendant's post-complaint behaviour, the key evidence in this case. DARVO explains a pattern by which the accused not only deny the alleged conduct, but then take the dramatic step of attacking the accuser, so much that they reverse the roles of victim and offender. Dr. Freyd's testimony, as applied here, assists jurors in evaluating whether defendant's aggressive response to Miss Lively's complaints follows a scientifically supported pattern. I mean, seriously, aggressive response, they apologised when everything was fine. when at the time she actually complained, they apologised. In fact, if anyone had an aggressive response to one of the times that she quote unquote made her complaint, it was Ryan Reynolds screaming for 6 hours. That's where DARVO should apply. Jesus. I can't believe the spin that's going on here, honest to God. Specifically, Dr. Freyd explains that defendants 1 denied misconduct when Baldoni claimed the complaints were taken the wrong way and all manipulation, and Heath essentially offered a performative acknowledgement of the women's experiences. 2, attacked Miss Lively when she raised concerns by becoming cold, irritated, and uncollaborative. Uncollaborative. And by shifting the focus from the misconduct to the accuser's character. And 3, reversed victim and offender by attempting to make themselves the victim of Miss Lively's unwillingness to take photos at the film's premiere, with Baldoni attacking Miss Lively's character in the press and filing lawsuits against Miss Lively in 3 jurisdictions to sue her into oblivion by accusing her of lying about her complaints to take control of the film. Right now I'm pissed off. Now I'm fucking pissed off. That's a lie. Oh my God, that is a lie. Saying to someone, no, I don't want to use your suggestions on my fucking film when you're the director is not being unwilling to collaborate. And I've already been through the DGA rules anyway, which says that the director is the only one with that level of authority. Right, okay. Suing her in 3 jurisdictions, right? Let me just break that down for you. She sued first in New York. They sued in response, right? That's the first thing. I think they both sued the same. No, they didn't sue the same day. Did they sue the same day? I'd have to look at it. They were very close in time. Lively definitely sued first in New York. She's talking about Jed Wallace in Texas, by the way, right? Who is now dismissed. So when she says defendants filed lawsuits against Miss Lively in 3 jurisdictions, she's not actually talking about Wayfarer here. She's talking about Jed Wallace suing her in Texas. And then she's also referring to the New York Times in California, which was not her at all. Just to, add some, I think, much needed context to that, because that is a lie. And I'm annoyed with that. And I know that because I follow each of those dockets very closely. Well, obviously the New York Times case was closed down, the one in California, because Wayfarer brought them into the lawsuit they had against Lively in New York. Ergo, they actually chose to relinquish one of those jurisdictions. But, regardless, it wasn't Lively that they were suing. It was the New York Times. And then finally, I believe she lied about her complaints to take control of the film. So, there. I'm so fucking angry with this already. I don't even know if I can get through it. Like, genuinely, this might be the time where it's just so much, even for me. I'm going to continue though, but the spin in this is just absolutely wild. It's getting continuously more and more brazen. Dr. Freyd will provide a framework for evaluating whether dependence counterattack fits DARVO's research-driven response by abusers, a response that is effective in rendering victims less believable. Do you know what is absolutely so upsetting to be reading this is all of this is over shit like, oh, you called my character's wardrobe, outfit sexy. That was it. There was no holding her against her will against a wall, no blocking her exit out of a room, no attempts to grope her or force himself on her. She did not lose anything, right? In fact, she got a PJ mark and she ended up, forcing her way into getting her own cut of the film. So if anything, she got promoted. And we're going through all of this and we've been bringing in experts to discuss DARVO. For this, when there are women out there who are going through some very real problems, who are being, hit, they are being controlled and have been long term, they are being sexually assaulted. There are people who, like Lyman said, some things that Lively has mentioned, if they happened in an office context, then maybe it might hit sexual harassment. But he was struggling with that. But in the situation they were, where they were trying to act and write scenes for a film, rehearse and plan for a film which involved sex and involved abuse, all of this shit is stuff that's been, extorted and taken out of context, miscommunications, or, and throw in a dash of opportunism as well from Lively. But I can't actually believe I'm sitting here reading all the reasons why Lively needs an expert on DARVO for the allegations that she made against Wayfarer, because her complaint is that low level, so low level it barely gets off the ground, and there are people experiencing so like very real problems who don't have access to people like Jennifer Freyd who can write these reports. They can't fund these kind of lawsuits, and Lively's here just taking the piss. And it's really it's hard to not get really angry or tearful over this because it's just so unnecessary. That's my little human moment. I can't believe it. I had none of this shit when I was going through it. When I was going through therapy, I weren't even allowed to go through therapy for the first 2 years of my police investigation into what happened to me because, I was told that they needed to preserve my raw emotion. So I had to sit with it for 2 years before I could even begin to start, to even go to my doctor and ask to be referred for mental health trauma support. And the waiting list for mental health support in the UK is years. I had to wait another 3 years on the waiting list to see someone to have things like EMDR and CBT therapy. I just find this absolutely batshit that we're here just for the contents of what Lively's put in her second amended complaint, or any complaint for that matter. Anyway, I'm going to pull it together again because I am if not a professional, so I will get through this. But this is about as hard. This is pushing me to my limit of I all the shit that there's been so much shit that Lively's pulled where I'm like, I can't believe she's doing this, but this is right up there towards the top. Absent Dr. Freyd's testimony, jurors may incorrectly assume that defendants' aggressive counterattack, including a PR campaign and litigation tactics attacking Miss Lively's character, necessarily implies the falsity of Miss Lively's complaint, rather than understanding that it can itself be a predictable response to being accused. Do you know what? I fully believe that this is entirely PR at this point. I do. I think this has got such inflammatory buzzwords in here that clearly don't apply to Lively. It's triggering a response to me as well, right? But if you imagine you're pro Lively and you read initial, you're like, oh my god, they actually destroyed this woman. She experienced such an awful traumatic time. And as many people who do not follow this case closely and do not know the full story, and they rely on the news headlines and watch what TMZ runs with, or one of the Lively friendlies, how it will be spun. This is precisely why Dr. Freyd opines that Wayfarer's entire defense in such court proceedings is a classic example of DARVO. So if you defend yourself, that's DARVO. That's just stupid, as. Dr. Freyd's testimony also provides jurors a behavioral framework to evaluate defendants' retaliatory animus. This testimony is especially critical given the court's response to defendants' arguments that they took no adverse employment action against Miss Lively because their actions were reasonably intended to protect themselves. The court noted there are limits to the response that the accused can make in response to claims of harassment. Indeed, there is an important difference between defending oneself on the one hand and threatening, intimidating, or otherwise interfering with someone's right to pursue a discrimination claim on the other. The court found that certain conduct by defendants could be construed as directed not at Lively's allegations and undermining their credibility, but as an attack on her professional reputation and livelihood, and that there is evidence from which a jury could find that the Wayfarer parties planned more aggressive action, not only to destroy Lively's accusations, but to destroy her and her career. The court specifically noted that there is some direct evidence that the plan to destroy Lively and her career was put into action, including through working to place all kinds of garbage on Lively in traditional media outlets. Yes, Taylor Swift cookie recipes, we all remember that completely destroyed Lively. I wouldn't mind if they, like Lively was saying, well, look, they made up false shit about me, and put it and circulated it in the media, and it did have a negative effect. I could see her logic there, but what she's saying is they went and found all my bad interviews over time and all the news articles of me being a complete shit and recirculated them, and then people realized that I'm actually an awful human being. It's still her conduct, and it's already been in the news, so putting it back in the news is hardly, I mean, what kind of smear campaign is that? Given the court's order finding that defendant's conduct could be construed as an attack, the jury should hear the DARVO framework to contextualize a research-based pattern of behavior. Defendants seek to exclude portions of Dr. Freyd's opinions only as they relate to DARVO on the basis that they are confusing, not helpful, or not necessary. But such testimony is especially necessary in light of Dr. Freyd's research showing that DARVO reduces the believability of victim reports when heard by third parties, and education about DARVO can reduce its negative impact on victims and observers. Dr. Freyd does not opine on whether retaliation occurred or whether defendants' explanations are truthful. She explains how jurors can evaluate defendants' post-complaint conduct without defaulting to lay assumptions that aggressive counterattacks necessarily imply the falsity of Miss Lively's underlying complaints. Defendants' reliance on namely, and Hugh, I'm not good with names, you all already know this, I make no apologies, is misplaced. Those cases prohibit expert testimony that instructs the jury on the law, resolving credibility disputes, or tells the jury what result to reach. Dr. Freyd does none of that here. She instead explains a recognized pattern of behavior so that the jury can better assess the evidence for itself. Okay. Testimony on betrayal, trauma, and institutional betrayal is admissible. Dr. Freyd's testimony on betrayal, trauma, and institutional betrayal, such as when an institution mistreats an individual, assists the jury to understand the workplace dynamics between Miss Lively and defendants, and avoid lay misconceptions about what workplace protections should look like when a complaint is raised. Dr. Freyd opines that Miss Lively experienced betrayal, trauma, and institutional betrayal at the hands of defendants and Wayfarer. Through their actions and interactions allowed this betrayal, trauma, and institutional betrayal to go on for longer than it likely would have had they responded adequately to concerns that Miss Lively raised. Indeed, research shows that institutional betrayal can occur through an employer's failure to protect when there is reasonable expectation to be protected, such as when an employee who reports being sexually harassed continues to be victimized after their employer fails to take action. Using a non-medical research tool called the IBQ-2 questionnaire and assuming the truth of allegations, Dr. Freyd opined on defendants' institutional response. For example, as to one IBQ-2 factor assessing whether the institution played a role in making it difficult to report experience, Dr. Freyd summarizes evidence that defendants never provided Miss Lively a HR resource, funneled all HR reporting back to them, and failed to have a HR department dedicated to the film. I'm sorry, she didn't see Lively's PGA letter. According to Lively was HR. She opines that Miss Lively's experience are consistent with many, if not all, of the behaviors captured by the IBQ-2 survey items. That institutional structure, combined with defendants' decision not to conduct an investigation after any complaints, provides the jury an institutional betrayal lens with which to view defendants' actions. That framework is essential to the jury's evaluation of the workplace environment in which Miss Lively raised concerns, including defendants' post-complaint retaliatory animus and defendants' claimed reasonableness of defensive measures. Without such context, jurors may otherwise assume with no basis that the absence of a formal HR investigation or Miss Lively's efforts to maintain professional working relationships after she complained of defendants' conduct reflect a reasonable institutional response by defendants. In fact, defendants are counting on the jury doing just that. Such a conclusion would be prejudicial to Miss Lively. That context is especially important in light of defendants' continued conduct. In defendants' April 10th, 2026 motion in limine number 12, defendants sought to exclude evidence of the contract rider agreement, a document that Miss Lively sent to Wayfarer in November 2023, in which she requested that Wayfarer agree to implement 17 protections to ensure a safe set going forward, arguing that the court should prohibit Lively from offering evidence or argument concerning the CRA for the purpose of proving liability or the existence of some prior wrongdoing. Ms. Lively insisted on the CRA provisions precisely because of defendants' failures to enforce the very policies they already had in place that prohibited workplace misconduct. Defendants refused to address the CRA's contents in the way Wayfarer's policies dictated such complaints should be addressed, namely via an investigation, and instead Baldoni simply decreed that the claims were all manipulation. The jury should assess defendants' reaction to the CRA and thus defendant's retaliatory motive in the context of Dr. Freyd's research-based institutional betrayal. Testimony on betrayal blindness is admissible. Dr. Freyd's testimony on betrayal blindness, the unawareness of betrayal trauma when individuals minimize, normalize, or delay confronting trusted actors about their conduct to preserve relationships, institutions, and social systems on which they depend, assist jurors in contextualizing seemingly counterintuitive behavior. Specifically, Dr. Freyd ties betrayal blindness to Miss Lively's very first interaction with Baldoni when he stated to Miss Lively that he was circumcised, which Miss Lively found disturbing. Miss Lively's reaction at the time was to write the comment off as taking a benign conversation too far, given it was one comment and he seemed nice. Dr. Freyd opines that this initial interaction between Miss Lively and Baldoni planted the seeds for betrayal blindness in Miss Lively's interactions with him going forward, whereby Miss Lively continued to give Baldoni the benefit of the doubt as he continued violating her boundaries. Dr. Freyd's testimony is crucial because it provides the jury a research-proven framework by which to assess seemingly counterintuitive behavior, how Miss Lively could simultaneously recognize problematic conduct while continuing her professional obligations with defendants. Without such context, jurors might incorrectly interpret Miss Lively's actions as counter to a reasonable good faith belief of harassing conduct, even though her actions followed a research-proven pattern to preserve a relationship. They may also incorrectly evaluate the timing of Miss Lively's complaints without understanding contextual research directly bearing on a complainant's delays in raising concerns. Defendants challenge a single sentence of Dr. Freyd's report relating to betrayal blindness. It is my opinion that Miss Lively's willingness to overlook this inappropriate comment regarding Baldoni stating he was circumcised reflected both a maturity in understanding that sometimes good people say inappropriate things, but also planted the seeds for a kind of low-level betrayal blindness, whereby Miss Lively continued to give Mr. Baldoni the benefit of the doubt as he continued to make inappropriate remarks and violate Miss Lively's boundaries in a sexually inappropriate way. To the extent defendants challenge that sentence alone or the broader theory of betrayal blindness generally, their argument rests on a mischaracterization of the theory. Defendants assert that this one sentence falls far short of a diagnosis. As set forth, infra, Dr. Freyd does not offer diagnoses. She offers social science research for context. Defendants also manufacture a fit question by wrongly defining betrayal blindness as suppression of a painful memory and arguing it is well within the ken of the ordinary juror. They then claim that Dr. Freyd's finding that Lively oscillated between awareness of Mr. Baldoni and Wayfarer's toxic behavior and an understandable desire to hope for the best has nothing to do with betrayal blindness. Defendants' arguments miss the mark. Properly defined, betrayal blindness provides context on how Miss Lively perceived, processed, and responded to defendants' conduct over time in order to preserve her working relationship. It is relevant in assessing both the objective and her subjective belief of harassing conduct. Accordingly, Dr. Freyd's testimony is admissible. Dr. Freyd's second opinion is admissible. Dr. Freyd's second opinion likewise satisfies Rule 702. Dr. Freyd opines that exposure to betrayal trauma, institutional betrayal, and DARVO is generally associated with an increased risk of symptoms of distress in the general population, and that here defendants' conduct, if true, put Miss Lively at increased risk of such responses consistent with research on these theories. This is going to annoy me. I really don't think this should be allowed in. I don't think this should be allowed in at all. Dr. Freyd also opines that each new instance of institutional betrayal exacerbates the harm of betrayal trauma. This testimony provides a lens with which to assess the compounding harm of multiple betrayals by defendants, where jurors might otherwise infer that Miss Lively's continued professional functioning negates the possibility of any distress associated with workplace betrayal. This context is particularly important given that alleged retaliatory acts are to be considered collectively rather than individually, and may take the form of a series of subtle yet damaging injuries. Without Dr. Freyd's testimony, jurors may neglect to see the cumulative nature of defendant's conduct. Accordingly, Dr. Freyd's opinions are admissible. Dr. Freyd's opinions are not offered as medical evidence of emotional distress. I don't think I'm going to agree with Lively here at all. No matter whatever she says, I'm sorry, I do think it crosses a line. I think Wayfarer are completely right to raise an objection to it. Defendant's assertion that Dr. Freyd's testimony on betrayal trauma and institutional betrayal must be excluded as medical evidence of emotional distress because Ms. Lively waived such evidence rests on a mischaracterization of Dr. Freyd's opinions. While the court barred medical evidence of emotional distress, it expressly permitted evidence of garden variety emotional distress, including evidence that the plaintiff suffered humiliation, anxiety, stress, embarrassment, loss of sleep, or loss of appetite. Yeah, but if she hasn't examined Lively, then how can she, testify to that? Dr. Freyd's testimony is not offered to prove emotional distress of any kind, nor is it offered to prove, as defendants claim, opinions regarding the trauma Lively supposedly suffered. Dr. Freyd will not testify that Miss Lively did, in fact, suffer any injury. She's just going to say that, there's a high risk. So they're going to insinuate it without any evidence, which I think is worse. Instead, as set forth supra, Dr. Freyd offers research-based testimony to rebut the faulty inference that Miss Lively's continued functioning negates the possibility of any distress. Indeed, Dr. Freyd's theories are measured using research tools that are not medical assessments. Because, that would be a good question. If she was so distressed she couldn't get out of bed and she couldn't take up the offered, oh God, what was it? She had a role on Saturday Night Live. A presenting role, I think, for the 50th anniversary. And she turned it down. Supposedly because she was too distressed. Yet she was able to, cut and edit It Ends With Us whilst, right after then she went on to Capri to film Another Simple Favor. And it does make you wonder, how were you able to function and then all of a sudden come September you flopped into your bed and could barely leave your home? Dr. Freyd's opinions are reliable as applied because they are not medical diagnoses that require a clinical evaluation. Defendants also mischaracterized Dr. Freyd's second opinion that defendants' actions put Miss Lively at increased risk of the symptoms of distress as an attempt to diagnose a patient. They then use that mischaracterization to argue that the absence of a clinical evaluation of Miss Lively renders the opinion unreliable in application. Notably, defendants do not contend that Dr. Freyd's general framework opinion on betrayal trauma, institutional betrayal, or related concepts is unreliable. To the contrary, they concede they are reliable in general. Defendants cannot credibly argue that those theories become unreliable merely because Dr. Freyd applies them to the allegations in this case without a clinical interview. Dr. Freyd does not purport to diagnose Miss Lively. Defendants themselves refer to the second opinion as not quite diagnosis. They also acknowledge that Dr. Freyd is not a therapist or licensed clinician. Rather, set forth supra, her opinions are offered for a different purpose, to provide a framework of proven patterns of behaviour. Courts have rejected the proposition that expert testimony grounded in social science research is inadmissible solely because the expert did not personally examine a litigant. For example, in the matter of NIR, the Second Circuit affirmed the District Court's judgment after the District Court permitted an expert psychologist's testimony that opined, without any clinical interviews, that the petitioner's abuse of the respondent would likely continue and there was high likelihood that the party's children would develop a psychological disorder should he witness such abuse. The court found that the petitioner cited to no authority, indicating that it is improper for a district court to rely on a psychologist's testimony if that testimony is based on social science research rather than in-person examination. Similarly, Dr. Freyd opines based on social science research that defendants' actions put Miss Lively at increased risk of certain symptoms. Defendants' cited cases are inapposite. Each involves experts who offered individualized diagnoses or medical conclusions. For example, in Chatat, no good with names, the court excluded a psychiatrist's testimony who diagnosed the plaintiff with paranoid schizophrenia and antisocial personality disorder, diagnoses drawn from the Diagnostic and Statistical Manual of Mental Disorders, so that's the DSM. Without conducting a patient interview for a reliably produced and accurate psychiatric diagnosis. Dr. Freyd offers no such opinions, and the remainder of defendants' cited cases all address experts who diagnosed or found the plaintiff to suffer from psychiatric conditions such as PTSD, major depressive disorder, bipolar disorder, or depression. Evaluated within their proper scope, Dr. Freyd's opinions reflect reliable principles applied for a non-diagnostic purpose and are therefore admissible under Rule 702. Dr. Freyd will not testify as a summation witness. Defendant's contention that Miss Lively intends to use Dr. Freyd as a summation witness misconstrues both the scope of Dr. Freyd's testimony and the governing standard. An expert does not become a summation witness merely by applying specialized knowledge to assumptions or explaining behavioral dynamics. At trial, Dr. Freyd will not narrate trial testimony, assess credibility, or instruct the jury what conclusion to reach. To the contrary, her testimony supplies jurors with a research-based lens to evaluate evidence they will hear from fact witnesses that they may otherwise misinterpret. What I'm hearing here is, Your Honour, we can't trust the jury to look at the no evidence that Lively has and, come to the conclusion that we want them to. So we want this paid lackey. I know she's an expert, but in this case, her report was that bad. To me, she's a paid lackey. We want this person who we've paid a lot of money to come and sit and tell the jury, now, in case it doesn't make sense to you and you can't see, the abuse, you can't see the harassment, you can't see the retaliation, let me tell you how you can see it. That's what I'm hearing. Indeed, Dr. Freyd's report expressly disclaims any role in fact-finding and repeatedly makes clear that her opinions are based on assumed facts. And contentions that an expert's assumptions are unfounded go to the weight, not the admissibility of testimony. Wholesale exclusion is unwarranted. Defendants cite to no case warranting exclusion of Dr. Freyd's testimony entirely. Any concern about overreach can be addressed through appropriate limitations, not wholesale exclusion. Excluding all testimony would improperly deprive the jury of relevant would improperly deprive the jury of relevant explanatory context and extend Rule 702 beyond its gatekeeping function. So that is the end of Library's opposition against Wayfarer's Daubert motion to exclude Jennifer Freyd. Oh, good God, that was something. That was difficult to get through. I find it so, I don't know, tell me if I'm wrong to be kind of feeling like this. I'm sure I'm not, and I'm sure a lot of you will probably agree, right? I just cannot believe that this warrants this level. Like, literally, someone who's an expert in significant abuse, enduring abuse, harassment, assault. I mean, some of the cases that they were citing to as well, relying on, it's like they were, like rape cases. And I know that they're not citing it for the rape, but you know what I mean? When you're trying to grab headlines, that's one quick way of doing it. And I'm so irritated that they have this expert giving this testimony. Yeah, I'm gonna need to go and think about this. The next video I'll be doing will be on Dr. Dina Maislin, who is the like a digital marketing and economics and all that kind of stuff, brands expert. So yeah, it'll be interesting to see how they, because we obviously heard in the opposition to exclude Nicole Alexander, Wayfarer's sort of, comparable expert witness who is meant to rebut Dina Maislin. We heard how awful Dina Maislin and, some of her methodologies, her report, etc., the limitations. I mean, it didn't make her look good at all. So I'm interested to see how Lively kind of frames it. All right, guys, thanks for listening, and yeah, we'll be back soon. And don't forget as well, actually, there's the hearing tomorrow, which I will try to cover. If it's over the phone, I will try to cover it. If it's in person, then I will be following on X. So obviously there's Matthew, the court reporter. He normally posts updates as these things are going on to his X account. So I will then, do a summary video then if that's the case. I will also be doing a sweep through as well after I've gone through these these oppositions to Daubert motions. I will then go through a sweep of all the other dockets and cases that I cover, try to grab any updates because I know several of them have got something going on in courtrooms, various hearings, etc., or trials even coming up in the month of May. So that's going to hit me like a ton of bricks. So keep me in your hearts and your thoughts.